But your case is so delay in filing the 34.
Yes, your
That's
lordship.
correct.
Yes, your lordship. Your lordship, so I'm just relying upon the judgment that is Your lordship, in fact, substantial payments have been made. Your lordship,
Let's appear for the respondent calculator.
Your lordship, my instructions are that only an amount of 12 lakhs was pending, which is, however, also supposedly paid, but
That's incorrect.
proofs of the same, your lordship, because there were different regional offices that were involved.
But
So, your
ma'am,
lordship, as on date, the only issue remains is in respect of the interest part, your lordship.
but ma'am, how do we condone the delay?
I completely bow down, your lordship. Only that the issue whether an appeal can be, your lordship, converted to a writ petition.
Where are you? Are you in your chamber?
No, your lordship, I'm at home. I had some medical.
This red
issue.
light is very strong.
So that's a curtain, your lordship.
Oh, I'm sorry.
Thank
you.
So, assist us.
Yes, your
How do
lordship.
we condone this? This is subsection 3 of section 34.
Yes, your lord. That there are
And
absolute
it is-
provisions. Yes, your
There is
lordship.
a delay of 120 days.
Yes, your lordship.
So, how do you
Your lordship,
assist us?
If I can be permitted to file a writ petition, your lordship, in respect of the judgment that is passed by the 3 judges bench in Tamil Nadu Cements versus MSME. Your lordship,
Facilitation Council would be amenable to writ jurisdiction.
Your lordship, that's the issue which is pending before a 5 judges bench, your lordship. In Tamil Nadu Cements versus Micro and Small Enterprises Facilitation
True, that's
Council.
exactly what my lord pointed out to you. But till that issue is not resolved, how will you avail the remedy of writ before the High Court?
File and keep it and wait for the judgment.
Your lordship, my difficulty is substantial amount is paid and my there are execution proceedings pending before the law court, your lordship. So I'm just trying to because your lordship, the case on merits is good, only that the pre-deposit was not arranged timely by BSNL because of interdepartmental approvals.
What do you have to say, Mr. Petkar?
Yes, Manoj. So far as the admitted facts are concerned, that is not what the reason is. Admittedly, award date is December 22. The certified copy they get in February 23. Section 34 is filed in November 23.
No,
Admitted
that's all
delay.
right. How much have you received and what is the interest as on today? Which
Well, it's an
For what
MSME
it is.
interest. The execution petition filed is a specific interest amount. I'll just indicate, Manoj. I have it in front
You
of me.
received 9 crores.
Manoj, the award says that 10 crores deducted by 9 crores. So as on the date of award, 1 crores along with the MSME interest.
according to you, how much is the interest accrued which you are executing now in the
Yes, Manoj. Manoj, it's 2 crore 81. It's an MSME interest because it's 3 times. The total pending amount is 281.
Your lordship, my only
And
submission.
my learned friend can always have her objection in the executing court if she thinks the interest is calculated incorrectly.
Miss
Shilpi.
Ms. Shilpi, should you not argue that my client is Bhartiya, what is?
BSNL, your lordship, it's a public.
BSNL?
Yes, your lordship.
That should be your first argument.
Yes, your lordship. I'm your lordship, it's all public money. I've taken that ground also, your lordship.
Public
because
money is not going to persuade us. Perhaps BSNL may persuade us.
I'm highly obliged, your lordship.
Issue notice for the purpose of some settlement. Today we are only concerned with the interest amount, full point, right? Mr. Petkar waives service of notice for and on behalf of the respondent. Should we send it for the mediation? Parties to appear before the Supreme Court Mediation Center on so and so date. Next matter.
Much grateful.
So better you sort it out. Otherwise, if it gets stuck in a writ petition, the earlier judge was also saying these awards are amenable to writ. Rohta's judgment, I remember.
I quite see what is falling from my lords. I'll instruct my clients.
Highly grateful. Highly grateful.
29, my lords, an SLP against the same order, my lords, have issued notice on delay as
Please
also on.
tag it.
Obliged, my lords.
My lords, in item 30, the relied upon judgment, it had, the appeal has been dismissed.
Oh, secure.
Secure. May I hand it over?
Then we'll have to issue. Sorry, relied upon it. So dismissed. Next matter.
Obliged.
Your Lordship, I am seeking pass over, Your Lordship. In
No Passover today.
Your Lordship, in that case, can adjourn for the Monday or Friday.
What is this matter?
Your Lordship,
Let's discuss.
this matter is regarding lifting of corporate veil, Your Lordship.
What corporate ways?
Your Lordship,
What? Huh?
Your Lordship, the decree was part ex parte, and I was the director in the company which was struck off.
Tuesday.
Come on.
Lord.
Monday.
Come on Monday.
Please, Your Lord.
Next Monday.
Deeply obliged.
Please, my lords. My lord, more than 2 years undergone 307, my lord. And, my lord, just recently, my lord, a person with a graver role, my lord, is released on bail. My lords may kindly have a look on this, my lord.
The trial has started.
Trial, my lord, I am not an accused in Gutsi talk. I am only an accused in 307. So, my lords directed that in Gutsi talk, the trial be finished in 6 months. There is a stay as per section 10 of the Gutsi talk act, my lord, because,
The same matter.
yes, same matter, my lord.
Man was brutally assaulted.
My lord, please see this. Please have a look on this order, my lord. Just recent order, my lord. A man with a graver role who was also an accused in Gutsi talk is, my lord, please see para 6. Kindly have a look at para 6, my lord.
No, that's, and here your lordships were pleased, at page 280, your lordships were pleased to dismiss the 307 of a co-accused on merits as well, my lords. Please see paragraph 6 at page 281, at paragraph 6, my lords, at 283. However, the petitioner has not been able to make out any case on merit so far as his plea for bail is concerned, more particularly having regard.
The problem is, last time also we had discussed this issue.
Yes,
There seems to be some provision in that good
section
talk
10.
Section 10.
that first the trial of good talk should be
Yes, my lord.
undertaken,
Yes,
completed, and then the IPC office.
yes, my lords.
Now, this man is not being prosecuted for
No,
Gutsi
no,
talk.
no, my lord.
So long as that Gutsi talk trial is not concluded,
Yes,
he can't pray for bail.
yes. Because that's dismissed on merits. He has to make out a case on merits, my
Where
lords.
is that order?
Of 281, my lords.
Annexure?
Annexure P17. PDF number.
That windmill problem. That windmill company, na?
Yes.
Yes, my lords, windmill, the co-accused, the petitioner before your lordships was my guard. In fact, he was to protect me.
And my lord, unknown persons, the TIP, my lord,
And
they
please-
said, they claimed that before the executive magistrate that the complainant Kanwar Jeet Singh was present and he identified.
283.
And my lord, whereas he was not present.
283.
Please.
Co-accused have now filed a stay application again in the
Para-
division.
What is the role attributed to this?
That he was my guard. He was there to protect me. In fact, he assaulted.
This,
Graver
That's
role,
under
my
the-
lord. I'm sorry.
this Rajku Bhai,
Yes, assault.
co-accused.
Yes, my lords.
Same type of allegation.
Yes, my lords. But on bail on goods in Gutsi talk, I pointed out your lordship's judgment to the court, my lords.
This man is not
Not for
prosecuted.
307. That's on Gutsi talk.
Idea in some of the accused for good talk.
Yes, my lord.
Some of the accused for IPC.
Because they
What
had,
is the idea?
because they had other cases as well. If you had a criminal antecedents, etc.
The way, how long should we keep him in?
But my lords, they are the ones who are delaying. After this, may I just pass on an order? The accused who are in Gutsi talk now have again filed a revision before the High Court
But
asking for stay.
We are not.
it is not within this man's control.
But then your lordship's order, my lords, at paragraph 6 dismisses it on merits, my lords.
But then
And earlier also for co-accused, your lordships had been pleased to dismiss while sitting in a different combination.
See, we have said 15. If that be so, the special court shall start with the recording of the evidence in good order.
Yes, my lords.
See to it that the entire trial. Now, this order is dated.
Your lordship's order is 16/7/2025.
Now, the problem is that this trial is not proceeding.
No, but please see para 6 also, my lords. Your lordships first dismissed it on merits, thereafter proceeded that the Gutsi talk trial should be completed in 6 months' time. Because that was the argument of Mr. Luthra who was appearing in that matter.
Para 6 of
Now,
order.
my lords, in the Gutsi talk, the coordinate bench of your lordship's court, my lords, has been pleased to grant bail to one of the accused persons. That person is not on bail in 307.
Now, we don't think that this Gutsi talk is going to get over in 6
No, it will not, my lords.
Para 7.
Yes, my lords.
Only 2 out of 41 witnesses.
Because now 4, but now there is a petition moved again, revision before the High Court for stay of proceedings.
It's not
Because they know the idea is not to let the Gutsi talk trial get completed and thereafter move for bail. That's the idea, my lords. Now again a petition before revision. May I pass on this order for
Over and above this man,
Yes,
how
my lord.
many else are in custody?
6?
They have not prayed for any bail.
No, it's what that was dismissed for 2 that was dismissed by your lordships, my lords, under 307. Because this person is my guard, he's there to protect me. I go to set up a plant, there's no role. Lordships examined that on 16/7 order.
Right, but we are only concerned with this delay.
But delay is not on our account, delay is on the account of the accused, my lords. They have filed an application in the High Court now again, after your lordships were pleased to direct that not direct or observe that that application was withdrawn. They filed it again. That state, every time they change their counsels, I can produce the order sheets before your lordships as far as the Gutsi talk matter is concerned, my lords. And lordships may see whether there's any delay on our part.
See this, we are not finding fault with you. Gutsi talk has to proceed. Gutsi talk may say take another 1 year or 2 years.
Yes, my lords.
Then the trial of this case will
Yes, my lord.
commence.
Yes.
By that time, though, he will complete.
6 months is the direction by your lordships in July.
Possible.
But
They'll come
provided
for
the-
extension. They'll
Lords,
come for
provided that the accused persons don't keep filing applications, that's why I'm saying.
Can't find fault with this man.
No, I
Because
bow
he's
down,
not
my lords, but-
concerned with Gutsi talk.
My lords,
The accused of Gutsi talk may be creating some problems.
it's a
2 years now.
it's a peculiar situation, but 2 years for a 307, my lords, it's a case under 307 where there were injuries caused. It's not a case for 307 without
The
injury.
matter, David, we know the matter. We have seen the photographs also of the injured person.
Yes, my lords.
But these are the hard facts. That's the problem.
Then allow me to file my reply, my lords. Let me place it on record then. To be heard on this. Lordships, my state is not here.
So you are not staying.
I am for the complainant, my lord.
Issue notice.
Lordship, please.
Dusty, permitted. You serve the standing
Please, ma'am.
counsel.
We'll do that.
Put it on next Monday.
And
My lord,
permit
they
us-
may waive, my lord.
We are waiving, my lords.
Please.
For us, not required, but a short counter, my lords, in a week's time we'll file.
You may file it, no problem.
Lordship.
We are only concerned with the delay.
I bow down. I understand. I'll place the delay part, my lords. Maybe a reiteration of your lordship's direction of the 16th July order, my lords, to the trial judge.
Won't make any difference
Because
because
of course it will, my lord, your lordship's court is, it'll make to the,
this order is dated
16th.
2nd of September.
Just
Yes, my
sent
lord.
order.
On 2nd September,
yes, my lords.
only 2 witnesses.
So now 4 have been examined out of 20. 4 have been examined out of 20. Therefore, the application by co-accused
We'll
must
see.
stay.
We'll see.
Lordship, please.
Please.
They may have to implead us, otherwise they will, our counter, etc. Those technicalities are there, may not be accepted, or lordships may implead us.
We permit the learned counsel appearing for the complainant to file his counter.
Lordship, please.
Registry
Obliged.
may accept the same.
I'm obliged.
Grateful.
Grateful.
Let's para 22 of the impugned order entirely proceeds on the basis that I did not deny receipt of this letter of 21st April. Now, this is completely contrary to the record notes. Completely contrary to the records. Your lordships will begin, I begin with the NCLT reply filed before the NCLT, page 304.
No pre-existing dispute according to you?
Absolutely none. This letter is a fabricated letter, and this is right from the beginning my pleading, my lords. My pointed pleading.
There's no denial to that.
No, it's not correct, my lords. Page 304, if your lordship sees first, and then I'll come one by one. The NCLT goes on that basis of that pleading and holds I did not receive that letter.
What is the amount involved?
Well, amount is 2 crores plus.
No.
1 crore 10.
1 crore 10 lakhs. I'm so sorry, 1 crore.
Balbir Singh, should you not sit and resolve?
Baladi, just to give a little back. No, there is
To whether 9 is maintainable, not maintainable.
Baladi, I'll deposit in the court.
You also, it's a one-off mail, assuming it to be true. Before that, after that,
No,
you
no.
don't say anything.
There's one more.
Credit notes not given, the
No.
last para in that.
Two things. Just to give a-
Pointed
just to-
denial, my lords.
Mr. Baladi, just one.
I'm not finished, sir.
So only today
We
the
were under the impression that the mail was not denied, but it appears it is.
It is
Today-
pointedly denied.
It is
Denied before the NCLT.
President suggested you should grab it.
No. The only thing which I'm saying today, the arbitrator has already been.
Well, this is the other problem,
The
Manoj.
arbitration notice was issued, which was not disclosed in Section 9 petition.
No.
Which was prior to time.
No.
They appeared after this. The order of the arbitration
Well,
they
it's-
appeared in Section 11.
This is an independent remedy.
Issue notice.
Please, Manoj.
What's your good name, sir?
Akash Nandolia.
Waive service of notice for and on behalf of the respondent. You file your counter.
Well, let us not proceed in the arbitration because this is
How
something.
can the arbitration be stopped today? They challenge the arbitration.
Very well. Let notice go, Manoj.
We'll make it
Very well.
available in 2 weeks.
Very well.
Next matter.
Gratefulness.
Wait, please, madam. High Court, Malatanda. It's on the very first day of listing of a PIL, the High Court takes it up, passes sweeping directions and disposes of the of the PIL on the very first day, filed at the instance, of a gentleman against whom, I have litigation pending. High Court records that. And then,
Demolition.
yes. But my instructions are the objectionable part we've already removed, on 25th January 2025, after the High Court order, that we have removed it.
In this petition, you were not implemented as party respondent.
We were parties.
You appeared or not?
My lawyer appeared on the first day. First listing
My
and the only
lord
listing.
didn't appear. How do I? Huh?
Sorry, Mala?
You said my lord appeared, but how do I appear?
No.
In fact, my lord's direction is there in our direction. High Court should monitor the illegal buildings in Calcutta.
No, that is fine, but we have already removed that objectionable part. My writ petition pending before the High Court, has been rendered nugatory, by this order. High Court records, in the order, if your lordships have, at page 13, paragraph 19.
What is wrong with this judgment?
What is wrong is this,
Tell us.
Now, because of this order, all my licenses are gone. My conversion is gone, High Court has come out.
Everything illegal, sir. Every bit of it. This is Calcutta, na?
Calcutta.
Huh. Now we are not going to say anything else because we have come down very heavily, and on the contrary, we have hailed the approach of the High Court that you must see to it that each and every unauthorized construction is brought down.
But High Court, we have already removed on 25th January, whatever, if your lordships have the page 16 direction,
No, we are not going to intervene.
asking the municipality to proceed with
This will dissuade the High Court. Next matter.
what I am saying is this.
No, sir. No.
It's the best left to the High Court.
No, next matter.
Lordship, I am appearing for Halishar Municipal Corporation.
It's all right.
My name may be recorded.
Okay.
May I say?
First you bring down the structure,
And
then
it's
your
already
name
done.
will come
It's
on
done.
record.
It's done on 25th of January.
Don't bring it down.
It's
this
done.
is not record.
It's
इनका नाम मत लिखिएगा वो report करेगा.
Lordship, it's done on 25th of January.
The next matter.
May I say this, let the High Court consider every other thing on merit,
It will
so far as the we have already removed that objection every part.
Consider everything. Dismissed. Next matter.
Obliged, Lordship.
Please, Your Lordship. I appear on behalf of the petitioner. I am challenging the interim order of the Honorable High Court. Your Lordship, I will
50,
54.
54.
Lordship, I
What
will,
is this interim order?
Lordship, in the impugned order, the Honorable High Court has passed an order for the petitioner to deposit 50% of the decretal amount.
But this is a first appeal.
Please,
You
Your
have
Lordship.
preferred a first appeal.
Please, Your Lordship.
You have suffered a money decree.
Please, Your Lordship.
Order 41, Rule 5.
Please, Your Lordship.
How do you come out of that?
I'll confine my submissions to 4 brief grounds, Your Lordship.
Fine. What is the amount? What is the decretal amount?
It's 24,28,000
With interest? The principal.
with interest. The principal is 18 lakhs. With interest, it becomes 24 lakhs.
Fine. Your first appeal is of the year
It's
2025.
2025. Yeah.
You don't want to make any deposit.
Your Lordship, please hear me.
Then the decree holder will proceed with the execution of the decree. Today, we are not going into the merits of your appeal. It's a money decree. Unless you show something very gross that you should be absolved of this deposit,
Your Lordship,
your appeal is heard.
we are not against depositing, but we are against depositing 50% of the entire decreed amount.
Then how much would you deposit?
Please, Your Lordship. Lordship, this was also raised before the learned trial court. Out of the 3 respondents, the 3 plaintiffs who filed the suit before the learned trial court, only one came to give evidence and came in the witness box to prove his claims. The other 2 plaintiffs never came in the witness box, and the claims, as far as those 2 plaintiffs is concerned, is not proved.
1 second.
It is a
Now, you have been ordered to deposit 50%.
So around 12 lakhs, which
but-
you don't want to deposit.
I-
You don't want to deposit.
I want to deposit even if for the sake of argument, if I want to deposit only 50% of one of the petitioner's shares. Your Lordship, there were 3 separate transactions of 6 lakh rupees, alleged separate transactions by each of the plaintiffs in this respondents herein. And only one of the plaintiffs came in the high court, in the trial court to prove his claim. The other 2 plaintiffs did not come to depose.
Is it a company or some partner
Individual.
firm or something?
No, Your Lordship.
Then how 3 individuals with 3 separate independent transactions preferred one particular suit?
They are real brothers, Your Lordship.
Ah, that's the-
You deposit 50%, on withdrawal,
Your Lordship,
was not there.
You deposit 50%. When time comes for the decree holder to withdraw it, we'll tell him to furnish some tangible security.
Your Lordship, then please allow the petitioner to submit bank guarantee, bank security, because Your Lordship, there is a history of litigation.
Also, you have to deposit back-to-back amount, please. You don't get bank guarantee without a back-to-back deposit.
Your Lordship, there is a history of litigations, and Your Lordship, the respondents are
You,
elderly citizens.
you have to deposit this amount with the court. After you deposit, the other side will say, now permit us to withdraw.
It's already permitted in this order.
Your Lordship, there is one more submission that this 50% includes the interest amount.
Amount will be dispersed to the respondents in the manner and proportion as contemplated in the impugned.
The undertaking only. Maybe 50% of that we can secure. Or we can secure the whole thing. That we can secure.
Your Lordship, also there is Order 41, Rule 5 does not provide for interest, Your Lordship. 50% as ordered by the High Court includes the interest, Your Lordship. So 50% of the principal amount, that too confined to one of the plaintiffs, is my humble request, Your Lordship.
You have to deposit, sir.
And then 6 months may be granted, Your Lordship, to the petitioner to deposit.
You made this request before the High Court.
And some security for release.
The petitioner is the original defendant. he has suffered a money decree. The judgment and decree passed by the trial court is now a subject matter of challenge before the High Court of Rajasthan by way of first appeal number 295 of 2025. The High Court has directed the petitioner herein to deposit 50% of the decreed amount, and subject to such deposit, the judgment and decree, money decree passed by the trial court would remain stayed from its operation, implementation, and execution. The High Court has also observed that once the amount is deposited, the same shall be disbursed to the decree holder, original plaintiffs. We do not find any error, much less any error of law, in the impugned order. However, the learned counsel fervently made an appeal before us that some time may be granted to deposit the 50% of the decretal amount. We are of the view that this request may be made before the High Court by way of a separate application. If any such application is filed, praying for some time to deposit, High Court may consider it appropriately. With the aforesaid, this petition stands.
Your Lordship, please allow, if they withdraw it, a security may be provided. A bank's.
First, you have to deposit it, right? After you deposit, then the stage will come for them to withdraw that amount. No?
It's
ordered in this order.
It is ordered, Your Lordship, that they will withdraw.
We also take notice of the fact that the High Court has permitted the decree holder, original plaintiffs, to withdraw the 50% amount that the judgment debtor would deposit as contemplated in the impugned judgment and decree, with the undertaking that if the judgment debtor succeeds in appeal, the plaintiffs would refund the same along with interest in accordance with law. Good point. We do not approve this. The High Court should have asked, or rather directed, the decree holder, original plaintiffs, to furnish some tangible security in the form of bank guarantee, etc., and not just asking for an undertaking. This aspect shall be kept in mind by the High Court while deciding the application which the petitioner herein may file, praying for time to deposit the amount. Next matter.
Much obliged.
May it please, my lord.
But supposing if you do not prefer this application, if you decide that I don't want to deposit, then how will the later part of our order come into operation?
In the event of
Order will revert.
We make it clear that if no such application is filed by the petitioner herein within a period of 2 weeks from today, then this order shall lapse. Our order shall lapse. Next.
Much obliged. Much obliged.
You thought of it. It will limbo.
54,
Yes, Mr. Chaudhary.
55 million.
55.
55.
55. This had come to be mentioned, Millard. It is regarding the transfer of the elephant from the petitioner's temple to respondent number 6. Millard, may I just indicate, since I had mentioned it on behalf of the state, what had happened after the order has been complied. But there was great unrest in the area of Kolhapur, Millard, since a lot of religious sentiments were attached. A meeting was convened. Now, Millard, there seems to be an agreement where respondent number 6 proposed to open up a center at Kolhapur. They have identified a land jointly.
Who are you?
Millard, I appear for the state, Millard, because it reached the state government and we had to mediate.
For MA? Show us the MA.
No, there's a. No, there is one.
You were the original petitioner, Mr. Chaudhary?
Yes, ma'am. I was
The judgment of the Bombay High Court.
yes, ma'am. Against the judgment of the High Court.
So now, why this MA is filed?
No, Millard.
Well,
Where is your MA?
no, my lord, we have not filed any MA. Your lordships had directed that the matter be listed again for compliance.
That the last order records was to be listed for compliance. That's
Get the MA, only one office report is there with
yes,
MA.
yes, yes.
15 times we were going around this computer.
No, my lord, there is no MA. We have
There is no MA, Milord, since
My
it
lord,
was.
we only want
We will record the complaint.
just the liberty to go back to the high power committee so that the matter can
Now,
some sort of
briefly, I can tell what the issue is. My lords had directed, the High Court said, please transfer this elephant from a particular Kolhapur place.
Why are you harassing this poor animal?
No, my lords, I'm the trust. I have no problem. I'm in Vantara, which is managing. It seems the state is facing an issue, which is the unrest, the social unrest in the state, in the city of Kolhapur, because of this temple belongs to a particular community where this elephant was there, my lords. Now the state, the position is
But the condition of the elephant was very bad.
very bad, my lords.
No, it wasn't.
After that we were called, my lords.
Suffered injury.
Yes, my lords. Yes.
The veterinaries had examined
Yes,
it.
yes.
Your lordship is absolutely
The
right.
elephant
Yes.
is not well.
Yes,
In
yes.
such circumstances, the decision was
Absolutely.
Absolutely.
The decision has been complied. Subsequent development. So as a trust, Maharaj, what we were called by the state, we have identified 7 acres of a plot. We will create a facility in the state of Kolhapur. And a city of Kolhapur, where we will provide the facility of doctors and the other facilities which are available. It's only on the request of the state because the state has faced this issue, which is a law order situation in the city of Kolhapur, my lords. Subject to my lords permitting, they going to the high power committee, and if the high power committee is satisfied with whatever the proposal is to be given by this particular trust and the state agreeing to it, my lords. That's the only purpose for which the today in a compliance, because the order was listed only for compliance.
Why are you nodding your head like that?
I was appearing for the original complainant, PETA, on whose complaint the elephant came to be transferred. My only submission to your lordship was, your lordship has rightly pointed out, there is no MA. If there are subsequent developments, there is no facility also. They're now proposing that they will establish a new facility to which they will transfer the animal. Those are not things that your lordship should be concerned with, because there is nothing in pleading. There is no basis on which to take cognizance of these developments. Without an MA, they are seeking to reopen your lordship's order.
Go to the committee then. Beta can also be.
We'll send you all to the high-powered committee.
Yes.
You also make your submissions. Mr. Balbir Singh, you also make
Please,
your
my lords, yes.
submissions. You also.
Yes.
And
you also.
we'll also.
What is this high-power committee?
So, my lord,
was
High Power Committee was originally constituted under an order of this honorable court to look into transfers of these scheduled animals. And my lord, that committee has been continuing ever since.
Who is heading it, Mr. Madhukar?
Yes, my lord. Justice Deepak Gupta is heading.
Right, Judge, that's the
Deepak Verma.
Deepak Verma.
That's a
Deepak Verma. My mistake. I apologize.
Initially, the Tripura High Court ordered to set up that committee,
Yes.
confirmed by the.
This matter has come up before us for reporting compliance. Our order dated 28th of July 2025 reads thus. Good. We are informed by the learned counsel appearing for the parties that the elephant was shifted from
Kolhapur.
to
Vantara.
Jamnagar.
Jamnagar.
Jamnagar. The elephant as on date is in Jamnagar.
yes.
A request has been made on behalf of the state of Maharashtra that in the wake of the transfer of the elephant, public sentiments have been hurt. In such circumstances, the parties have reached to a consensus that the entire issue be looked into by the high power committee constituted by this court
Please, my lords.
in
No, Lord, it was constituted by the
Where?
Honorable Tripura.
No, where is it?
Confirmed by this court.
Where is it?
But by the High Court, the Tripura High Court order dated
एक मिनट भाई क्या लिखा आपने
711.
वो सब जाने दो कंसेंसस वाला पढ़िए by a high power, it is called high powered committee.
Please, man.
It is powered
Powered, man.
high powered committee
Please, man.
chaired by
retired judge of,
chaired by a former judge of this court.
yes,
We are informed that this high-powered committee was directed to be constituted by the Tripura High Court
yes, by order dated 7th November 2022, Millards. Passed in writ petition civil number 17 of 2022, titled as Sudipta Nath versus Union of India. I'll just pass it.
Just write in or give it.
That's at page 11.
This order of the Tripura High Court ultimately came to be affirmed
Yes,
by this.
this court. I'll give the details. Millards.
With the order dated so-and-so, passed in so-and-so.
That's at page 39.
Let the parties appear before the high-powered committee
Please, Millards.
and the issues be resolved accordingly.
Deeply obliged.
Great.
Great, please. Just keep it.
May I make one request, Your Lordship? There is a change in circumstances. If there is no change in circumstances.
Likhiye, it is needless to clarify that the high-powered committee shall hear all the stakeholders,
Very well.
including the original
Complaint.
complainant, the
Peter,
writ petitioner before the High Court.
the complainant before the High Power.
You were the writ petitioner, na?
Not
No, I was the writ petitioner. The high power committee passed an order against us. We filed a writ petition. They were the
All stakeholders.
Original complaint
Yes,
before the High Court.
Original complainant before the high-powered committee.
Yes.
Great.
let
Deeply
it be decided without getting influenced by the observations made by the High Court, Milord, because that's
This court's on this time.
Well,
no.
since the parties have decided to go before the high-powered committee and get the issues resolved, the high-powered committee may take an appropriate decision without being influenced by the original judgment of the.
yes, I am so.
They are really saying that there is a subsequent development.
My friend is just a
New facility. If there is
You go before the high-powered.
Very well, Millards.
I am so.
This is too much, sorry to say. And state of Maharashtra, if you will keep succumbing to public sentiments against judicial orders, there will be no rule of law tomorrow.
No, Milord. May I clarify?
Once there is a judgment of
I quite
the
see.
court, matter travels to the Supreme Court, it is affirmed as a state, it is your duty.
We did that,
to it
Milord.
that
We did that. We did everything, Milord.
Very
But
dangerous, very dangerous.
Milord, may I only indicate the scale of this?
You can't bring public sentiment.
No, Milord. May I only indicate the scale of this?
To abide by the law.
Milord, I quite see that, Milord, and we tried everything.
Next matter.
Grateful.
Please, my lord. My lord, this petition is arising out of the same common judgment, my lord, which is impugned in item 56, my lord. That CPS college, that diploma college. Yes.
Oh, that Mr. Singh's
Yes.
matter.
Yes, my lord.
Mr. Singh's matter.
Yes. My lord, this matter may be tagged with this matter.
Your Lordship said.
When should we fix the hearing now?
Lord, only one small request, Lord. Your Lordship.
Now there is no problem. The bench will continue.
Very good. Lord, there is only one small request I want to make, Lord. This is an institution only for the interim order. If your Lordship permit me only 5 minutes. This is an institution functioning since 1912, recognized in the 1916 Medical Degrees Act, recognized in the 1933 MCI Act, recognized in the 56 MCI Act, and even the current Act says, Lord, that the savings and Lord accepts this. From Lord 56 to 92, if your Lordship will just recall the Indian Medical Council Act regime, from 56 to 92, there was no bar on anybody setting up Lord or starting a new course. That is why 10A, 10B, 10C were inserted. Your Lordship will recall that. Now 10A, 10B, 10C were inserted and it said everybody will have to go to the MCI for the purpose of starting a new course. 2000, the PG regulation came. The PG regulation said that anybody granting, and just have that one page only, anybody granting a postgraduate degree prior to 93, that is prior to the amendment, will be permitted to grant more degrees. Just have a look at that one document only, Lord. And
what are you?
I am only saying, Lord, that these are students who have been admitted when admittedly it was a recognized course.
But they continued, na?
They have continued, but they can't take the exam. They can't take the exam.
No, the reason.
So, Your Lordship, I am not saying, just one second, I am not saying, Lord, give me any relief. I am for the institution. I'm only, there are,
Hours. Ordinarily, the exams would be taken in which month?
I have to hold the examination, Lord. I have to hold the examination.
For last year also?
Yes, Lord.
For 23, 24?
Because all these students, Lord, it's no fault of theirs. Whatever we are legal position, it is not the fault of theirs. So at least their exam can be conducted. Your Lordship may even make that subject to outcome. But at least, Lord, because the Attorney General obviously, Lord, will appear, he'll also take some time.
What happened
It can't
is,
be.
Milord, there is a,
The problem is this.
Who are you, Mr. Chaudhary?
Milord, I am the PIL petitioner. I was the PIL petitioner. And,
How are you concerned with this?
Milord, my petition got allowed, Milord, and it is
How
found
are
that
you
they were
concerned
illegal.
with these colleges?
No, Milord,
That is highly questionable, but I don't want to get it.
How did you conceive the idea of preferring?
Milord, I am the erstwhile president of Maharashtra Medical Council. And Milord, I found everything which was being done by them was illegal. The colleges, institutions were run without seeking proper permission.
Wait a minute.
Yes.
Milord,
MBBS. We need to hear this matter and
Yes.
then
Yes.
we'll take an appropriate.
Yes.
What do you propose to do with the students?
Now, Milord, that's what.
Supposing if we dismiss this petition and affirm the judgment of
Yes.
the High Court, Bombay High Court, that's the end of it.
No, still your Lordship will protect the student. Lordship have done that.
But protection of students,
In any case, we'll have to.
which academic year?
Milord, let me.
Which academic year?
22.
Milord, I'm appearing for NMC, Milord. On the last day, Milord had to issue notice to the Attorney General, Milord.
That's
Milord,
the
we have
reason why it is
conveyed
kept-
him, Milord. He may be joining online also because he's.
Yeah, I've already joined. Already joined.
Milord,
Your Lordship
government
had-
will have to take a call, Milord. The reason is, Milord, the course was discontinued in the year 2009, Milord. Then again in 17 for few subjects, it was started for 5 colleges. What mischief they have done is, Milord, they had en masse allowed private hospitals to conduct the course. They are not an examining body.
Not government hospitals. Government hospitals, not private.
5.
What were you all doing?
I beg your pardon, Milord.
Let's start it once again.
Milord, we continuously, that's why we de-recognized it. We continuously de-recognize them, Milord. Then they manage from the state, where the state has no power, Milord. Milord, in this, what I'm suggesting is, Milord, let government take a final call on it, this, Milord, because these colleges or these students are not legally admitted.
Government means union? Union
Yes,
Union of India.
Union of India.
That's the reason why your Lordship.
I've locked in. I've locked in.
We were sent by the governments of Maharashtra and Gujarat. We were sent to the
5 colleges.
no. We were sent to various government
Apart
hospitals.
from that, Milord, this
That's the real problem.
society has managed themselves, Milord.
But allow the Attorney General to
Please,
speak
Malak.
something, na?
Please, my lords, he may be in our favor.
Mr. Attorney General, we are waiting for you to say
No,
something.
I didn't want to interrupt. I didn't want to interrupt the flow of other council's argument. Now, today, the only question is to whether the students who have already enrolled, if their fate has to be taken care of and addressed, without going into the larger questions. I had a discussion. Probably, if you are going on that direction, give me about 2 to 3 weeks time to find out which is the best modality so that we don't skip again. So give about 2 to 3 weeks time, find out what can be done, because it's a question of holding an examination in a proper way. It is not.
Have the matter itself, Lord. Otherwise, Lord, don't keep the whole thing in limbo.
As far as the merits of the matter is
My
concerned,
friend is not agreeing for an interim order today, then if after 2 weeks, whatever your Lordship said is.
This can be recorded, Mr. Singh, that they are contemplating mechanisms to regularize. the
Exactly.
degree of students.
Only for the
Suppose they come
purpose
out
of.
with some
Yes, why not?
Exam,
Why not? That can be recorded. That can.
Only for the purpose of holding the examinations.
The learned Attorney General is able to persuade the government
That's
to work out some modality.
yes, Lord. That will be.
Our own interest.
Yes, absolutely. At least of the students. I will still be wanting, Lord, an early decision, but at least for the students, Lord, it will be.
Of course, the persuasive power of the Attorney General need not be doubted.
Pardon?
I said the persuasive power of the AG need not be doubted.
Don't doubt at all, Mr. You have all the power and the might.
Is the Attorney General for India.
Yes, for it. Due to paucity of time, we are unable to start with the hearing of this matter. We are conscious of the fact that this litigation has something to do with future of hundreds of students. Full point. Today, the only concern is about the examination to be conducted by the colleges concerned.
No, by the petitioner, Lord. We can't. We are an examining body only. We are examining body.
The College of Physicians and Surgeons.
Examining body.
By the examining body.
The institution, Lord.
Institution,
I'm
College of Physicians.
By the college of,
Institution will not do it.
by the institution, namely the College of Physician and Surgeon, right?
That's right.
We requested Mr. Venkatramani, the learned Attorney General for India, to intervene and assist this court in this litigation. Learned Attorney General would submit that he would speak to the authorities concerned and try to work out the modalities so as to protect the interest of the students who have already been admitted and are
Awaiting exam.
awaiting conduct of the examination. The learned Attorney General prays for 3 weeks' time to come back.
Lord, he said 2 or 3. Could you Lord give
I said, let it be 3 weeks' time.
3 weeks' time. 3 weeks' time. क्या लिखा आपने? 3 weeks' time to come back with some arrangement by which the interest of the students can be protected. But we have yet to hear the matter on its own merits. In other words, we have yet to look into the impugned judgment rendered by the High Court in public interest. However, our first endeavor should be to see that the students are not left in lurch in this particular fight between the college, original petitioner, and the government. We request the learned Attorney General to work out something and come back to us after 3 weeks. By any chance, if some viable solution is not brought around, we shall proceed to hear the entire matter on its own merits.
Very deeply obliged.
Okay, sir, Mr. Attorney?
Absolutely not. Absolutely not.
Okay.
Some date immediately after 3 weeks.
Should we keep it on 3rd October is a holiday?
3rd is a holiday, Lord.
It's a holiday.
Then we could put it on any NMD day.
It could be.
7th of October, Tuesday.
7th is already.
Huh?
Tuesday.
7th of October.
Top of the board, Lord.
Top.
Deeply obliged.
Could it be on 8th if your lordships will not find
8th of
it?
8th of
Deeply obliged.
Grateful.
My lord, item 57 may be tagged with this 56 minutes.
No, we dismiss it.
No, my lord.
Dismiss it.
No, no.
Okay.
Grateful. My lord, 56 days delay is there.
How much?
56 days.
56 serial number and 56 days.
Yes, tallied it.
Okay, chalo, delay condo.
It's an entry tax matter, my lord.
Tax. But what? Yeah, we can. 16.
We'll sit up to 1 o'clock. Call. Any matter, we can take it up and finish it up. Any matter, any fair available.
I appear in the entry tax group. We want to withdraw a matter in that. That is
For usual order, because he must have availed the benefit of that scheme.
amnesty scheme. It's 301.170. The item number is 301.
Sasnam, that is a different bench. That quorum is in the afternoon.
No, I was told the bench is not sitting or is continuing at 2, Your Lordship. I'll mention at 2 o'clock again.
301 wali.
That's at 2 p.m. with.
Your Lordship, I'll mention at 2. I was told it was not. Apologies, Your Lordship. Apologies.
My lords, I'm appearing for respondent number 2 to 4.
Call up, Sirivas.
Well, as your lordships asked a question, there are some longish matters which your lordship may adjourn subject to item 40 was for final disposal anyway, since your lordship is rising. Otherwise, I leave it to my lords, we are ready. Item 40.
We'll be able to sit maximum up to 1 o'clock.
That's what I heard, Milord. That's why I intervened, because the lordship said so. I don't
Keep
think
it on some other date.
lordship pleases.
Any urgency in the matter?
No, but this is a final hearing on an issue of law. Just 5 seconds, brother, about whether establishment means protected workmen per unit, per branch, or for the whole establishment as a whole. It's an IDM. It's a legal issue to be decided.
We'll give you some date. We'll give you some.
Lordship may indicate some date. Very well.
Proceed.
My lords, I'm appearing for respondent number 2 to 4. I'm seeking some time to file reply, my lords.
In 32?
Yes.
32, my lord. Service is complete, my lord.
Agent.
It's my lord. Lordship, in item number 33, I am humbly seeking interim bail, my lord, because already I have underwent 45 years. And my lord, I am 68 years old man.
Wait a minute.
Please, my lord.
We have already issued notice in this matter.
Yes, my lord.
I observed something last time now.
Please, my lord.
What is the date of that order? What is the date of? While you were on parole, you committed one another murder.
But at the age of 28, my lord. Thereafter.
Age is not relevant. You are now not entitled to seek any remission.
No, I am entitled to seek remission, my lord. Thereafter, I received about 10 years remission, my lord. That is what the custody certificate says. Even thereafter, my lord, I was enlarged on parole, and there are no other offences alleged against me thereafter, my lord.
You may be out of touch with your skill also.
Totally now I am reformed, my lord. Kindly appreciate. Page number 40, the advisory board has already recommended.
You have invoked Article 32
Please,
for
my lord.
us.
Please.
And in this petition, you are now seeking for bail.
Yes, my lord. This honor, please.
In connection with the first offense,
Please, my lord.
you were convicted and sentenced to undergo life imprisonment.
Please, my lord.
Did you prefer any appeal in the High Court?
Yes, my lord.
Dismissed?
Yes, my lord.
You didn't come to the Supreme Court.
No, my lord.
Then you committed second offense. Trial court has held you guilty.
Please, my lord.
Sentenced to life imprisonment.
Please, my lord.
Have you preferred any appeal in the High Court?
That is dismissed, my lord.
So you have not challenged both the judgments.
No, my lord.
In such a scenario, how do we release you on bail in this petition?
Lordship, in that liquor tragedy case, in very infamous liquor tragedy Kerala.
If your conviction has attained finality, and if we release you on bail,
this honorable court, my lord, let me explain it. This honorable court, in a similar petition, in that case, my lord, 31 persons were died.
this man is in custody past 45 years.
35 actual sentence and 11 years.
So, what is the stance of the state here in this case? What have you to say?
What is the
What is the policy?
20 years, my lord.
As far as the conduct of the person is concerned, I got a certificate that he is.
Are you ready to consider his plea for remission? We
Your
record
Lordship may direct the authorities to consider again. That will be better.
Lordship, already,
The applicable policy.
my lord, already
As per-
there is a direction from the Honorable High Court. They did not consider it. Page number 41.
Keep it pending. Our order dated 22nd of August 2025 reads thus. In pursuance of our aforesaid order, Mr.
Nishre Rajan Shankar.
Learned Counsel, Mr. So-and-so, the Learned Counsel has appeared on behalf of the state of
Kerala.
Kerala. Full point. Next. The Learned Counsel appearing for the petitioner submitted that his client is in jail past almost 45 years. According to the Learned Counsel appearing for the state, the petitioner could be said to be undergoing sentence past 35 years. Full point. Be that as it may, we are of the view that the petitioner should immediately prefer an appropriate representation addressed to the competent authority of the state government and pray for remission of the sentence. We grant 2 weeks' time to prefer such representation.
Already preferred, my lord, as per the direction of the High Court. That is page number 41. They did not release me. That is why I am before this Honorable
They
Court.
have taken some decision on that representation.
My lord, no decision. That is written in my writ.
Not been communicated with any decision.
No, my lord.
Where is
Many,
that representation?
kindly see page number 41, my lord.
Annexure?
Page number 41, that is High Court judgment, my lord. Annexure P1.
The item number
Many applications I have filed.
20.
Page number 41, my lord. Many applications I have filed as per the
The last one. The last in point of time.
Your lordship, that is immediately after delivering. Please.
Any difficulty in referring to them, you are there advising, and with our order, file it will have a.
Then lordship, I will do, kindly keep my repetition pending here. Otherwise, they will dismiss it.
Full point. We grant 2 weeks' time to the petitioner to prefer an appropriate representation. Full point. Once the representation is received by the state government, the same shall be looked into immediately and an appropriate decision shall be taken within a period of 4 weeks thereof. And place the appropriate report or decision in that regard before us. Good point. Right? Okay. So 2 weeks and 1 week, 4 weeks. Post this matter once again after 8 weeks. The Learned Counsel appearing for the state of Kerala shall inform about this order to his client and shall also see to it that the appropriate decision is taken on the representation that may be filed by the petitioner. Okay? Sure. Next.
Oblige.
34, please, Your Lordship. In 34, Your Lordship, his application for remission has been accepted and he will be released within a short time, Your Lordship.
Likho. The Learned Counsel, sorry, 1 minute. Your appeal is dismissed by the High Court.
I'm for the state, Your Lordship.
My lords, the appeal was dismissed and confirmed by the, this is after notice matter, my lords. The appeal SLP petitioner has already undergone the custody.
SLP is also dismissed.
No, my lord, this is pending. This is SLP against the conviction order, confirm order.
Okay. You have already taken a decision.
It is taken a decision on 22nd of August 2025.
But leave is not granted.
Not, my lords.
This petition arises from the judgment and order passed by the High Court of Judicature at Allahabad, dated 10th of January 2018, in jail appeal number 3824 of 2017, by which the appeal preferred by the petitioner herein against the judgment and order of conviction passed by the trial court came to be dismissed. Good point. He is undergoing sentence for
Approaching 17 years, my lords.
We are informed that the petitioner is undergoing life imprisonment past 17 years. Full point. Mr.
Garvesh Kabra.
The learned counsel appearing for the state has instructions to make a statement that the government has decided to remit the sentence. Within a short period of time, appropriate orders would be passed and the petitioner would be released from jail. Let this exercise be completed within a period of 4 weeks from today. Okay? The petition stands disposed of accordingly.
Your Lordship, one just line that if he is not wanted in any other case. Yes.
Goes without saying. Next matter.
Yes. Much obliged, my lord. I'm great.
I'm seeking a pass for my lords.
Janet.
My lords, at item 35, my lords, I'm being led by Mr. Srinath Sridevan, my lords, from Chennai High Court. He's in another matter, my lords. Could your lordship kindly have it next week, my lords? Next Thursday or Friday, subject to your lordship's convenience.
35. We have already adjourned 35.
You've passed it over, my lords.
Jen.
Oh, I'm sorry.
She wanted Passover.
Oh, very well, my lords. Could your lordships have it next Thursday, my lord, subject to your lordship's convenience? Very well, my lords.
Yes.
May it please the Lordship. My Lord, against a concurrent finding of facts by trial court and first appellate court,
correct.
The second appellate court they overturned the judgment, my Lord.
Who are you? Plaintiff.
I am for the plaintiff.
What was your suit about?
Sued for specific performance of contract.
Specific
It was decreed.
performance.
It was decreed by the trial.
Specific performance. Agreement of which year?
Agreement is 2001. My Lord, one thing is, after this judgment passed by the High Court, we preferred an appeal and your also issued notice. And he appeared in caveat. By the time the caveat, he did not bring it to the your lordship's notice. When he appeared, he has disposed of the suit property. He had no substituting title.
Purchaser has and
The purchaser are not before your lordships.
okay. Relax.
You can always be asked to convey again. There are judgments of this court of
My
similar.
lord, my lord,
Wanted to
They
get
can't run
rid
a
of
race with
you.
this court.
my
He
lord, my
wanted to get rid of you, so he has sold it off.
lord.
What else can
Keep those judgments where if you succeed,
2001 is the date of the agreement.
Agreement, my lord.
What is the sale consideration?
Sale consideration is 2 lakhs.
Why should we go into it now? Since you are bringing it to our notice, we should implement the subsequent.
unless we find merit in it.
Okay. 2001 is the agreement.
Agreement, my lord.
What is the sale consideration?
Sale consideration 2 lakhs, we paid 1.5 lakhs.
By what time the sale deed was to be executed?
My lord, the sale deed was to, because by that time it was to be executed within 3 years.
3 years.
The reason is
Your suit came to be allowed.
allowed,
First appeal came to be dismissed.
dismissed. No,
Now, what weight with the High Court in second appeal in reversing the decree of
my lord,
performance?
second appellate court said it was that way by mortgage.
Achha.
But it was not a mortgage, it was a consistent case of the plaintiff that it was a specific purpose contract, it was an agreement for sale. They took the plea.
What is this, land?
Land is a small dilapidated house. They are husband and wife, they are no more. They died issueless, and the present respondent is, he claims to be adopted son. And after he came to the picture added as a party.
Come to para 40 of the impugned judgment, sir. Come to para 40.
Admitted loan.
Come to para 40.
Whenever huge consideration is given and something is left, which you can start with the presumption that it is a loan. Just read 40.
Come to para 40.
Or 40.
It is admitted that the defendant has received
since it is admitted the defendant is received a sum of rupees 1,50,000 by way of loan, it is not a loan, my lord. It is his case is there.
Sir,
I am reading out.
please read it as it
My lord.
is.
From the respondent plaintiff under Exhibit A1, the appellant is directed to repay the entire amount of 1,50,000, though it is stated that the defendant paid some amount by way of interest. This court is unable to deduct any amount paid by way of interest.
So he has to pay you 1,50,000 at the rate of 12% interest, right? Now
I know.
come straight to para 38. That should clinch the issue. Come straight to para 38.
Good. The suit property is an extent of 2 cents of land within the municipal limits of Velo town. More than the value of the building, the value of the land would be high. This court also accepts the plea that the sale price mentioned in Exhibit A1 is far below the market value as on the date of sale agreement.
Correct appreciation.
My lord, there was no evidence.
Next pattern.
My lord, there was no evidence at all.
Next pattern.
My lord, there was no evidence.
No, sir.
My lord, I will argue on this case on merit.
Court should not deprive somebody.
My lord, I will argue this case on merit.
1,50,000. Have you paid him back?
No, my lord.
We have deposited.
Deposited? Okay.
My lord.
fine. Next matter. 38.
My lord, your lordship should have heard the matter on merit.
No, sir. Thank you.
37.
Huh?
We were not
I
there.
mentioned in the morning because
We were not there. That's all right, Lord. I'm just asking if I have some difficulty. Lordships have kept it on Tuesday. Can we have it on 7th?
Okay, 7th.
Seventh, same top of the wood.
Top of the
Deeply obliged.
Like 38.
Multiple respondents are not involved or they are not able to. Bar also accepted.
You know the better.
She's on good faith.
Everything is on good faith. Less said the better. Who appears in 38?
Well, some for the petitioner, my lord.
Yes,
Notice
what
was
is
issued for the limited purpose of mediation, my lord.
Mediation?
Please, my lord.
My lords, I am appearing for the respondent. My lord, my instructions are that though notice was issued on 17th February, no offer at all has been presented by the petitioner side. In fact, my instructing
My
counsel reached
instruction
out.
is the president of the Sangam has been admitted in the hospital. They have tried with him. They have said, may I request, my lords, may be referred to the mediation center.
One last
My
opportunity.
lords, may I please request, my lords?
You
Can it
talk
be,
to the other side.
please, my lords, can it be referred to the Supreme Court mediation center, my lords? In that way, both the parties will.
Chalo, inko Supreme Court Mediation Center, which one?
Obliged.
Very well, my lords.
There's a letter.
Yes, my lords. Please, my lords. I'm for the petitioner. Lords, while issuing notice, my lords were pleased to observe.
You have circulated the letter?
No, my lords. No, not the other side has
Yes,
circulated
other
the
side.
letter. So while issuing notice, my lords were pleased to, my lord, observe that if this matter can be settled by us paying some reasonable amount, because lords really in that sense have today paid.
Have you all talked or not?
Lords, in the reply, they say that they're not willing to really offer anything. But lords, in fact, we are willing to offer some reasonable, my lord,
Would you all
proposal.
like to go before the Supreme Court Mediation Center?
We can try that.
Huh?
Yes, I mean, connected. We can try that.
Send them to the try,
My lord.
failing which will hear it out.
Lordships, please. Lordships, please.
Next match.
My lords, I'm obliged.
Who have 40, Mr. Dr. Singhvi was there. 40 we prayed for.
We adjourned it.
We have adjourned it. Next matter.
Your Lordship. Your Lordship, this is an appeal filed by the father after this Honorable Court exercised its powers under 142, closing, one, dissolving the marriage, two, closing the criminal matters between the parties, and leaving the aspect of guardianship to be decided by the family court, by the guardianship court. The matter thereafter and the aspect to be decided before the family court is one aspect. There was a counselor report, expert report that was called for by the High Court when the mother made an allegation that the father had shown the daughter during one visitation an objectionable photograph. No details of what this objectionable photograph is. Thereafter, the daughter told the mother on the very same day of this visitation. The mother sends the daughter for visitation the next time, and this allegation is thereafter made at the fag end of trial when the family court is to pronounce judgment after trial.
Your application was partly allowed.
My application is partly allowed. Today,
You put an application under Order 18, Rule 17
Yes.
for further cross-examination.
Yes, sir.
And in what manner it came to be partly allowed?
Sir, it came to be allowed to the extent that the father can lead evidence in order to establish a good relationship with the child, and he can produce any other witnesses to that effect. It came to be dismissed on the aspect of cross-examining of these experts who gave the expert report.
What type of expert report?
It was a child psychiatrist.
You want to cross-examine the psychiatrist?
Sir.
Why? For what?
If your lordship has the reports, the two reports that are there, they are in themselves deciding the matter. Experts were appointed under section 12.
And the litigation is at what stage now?
The trial after trial and a judgment that came from the family court in the guardianship matter, the matter was remanded to consider the aspect of the findings of this expert report. The trial in that has commenced. It is a time-bound trial to be finished.
Now, in that proceedings, you moved this application
No,
under
sir.
Order 18.
Yes, sir, in those proceedings.
That is too much.
Your lordship may see just on section 12 of the Family Courts Act.
You can cross-examine any other witness as permitted by the High Court. But to summon those psychiatrists...
If your lordship just notices, if this were, because the nature of allegation that is made is
What is
again...
the age of the child?
She's 15.
Why are you all harassing her?
Your lordship, she had a perfect relationship with me. In fact, in October of 2022, a court-appointed commissioner looks at the visitation, conducts the visitation and says the child has a good relationship with the father. 1 month later, this allegation is made and my access is thereafter stopped. 1 month later, that I have shown objectionable photos. There are photographs of happy times of this visitation of 20th of November 2022. The mother then volunteers the daughter, if the father has shown the daughter such objectionable photos and has not cared for the welfare, the visitation is given on the 3rd of December.
What is the gross error in this order passed by the High Court? According to you, what is that error which warrants interference at our instance in exercise of our jurisdiction under
If your lordship has section 12, if your lordship has section 12 of the Family Courts Act first, for a moment.
First thing, ma'am.
Sir.
Order 18, Rule 17 has nothing to do with the litigant. It is the power of the court. If the court wants some clarification, it can invoke Order 18, Rule 17 and summon a witness for the purpose of clarification. You cannot, as a party to the litigation, invoke Order 18, Rule 17.
If your lordship has, if your lordship would have the Family Courts Act for a moment. It is only because under the POCSO Act, if your lordship would to consider.
Now proceed with whatever High Court has permitted you to do and don't harass this poor girl. Next time.
Yes, Your Lordship, may I please submit? I am the respondent, mother. Sir, I have moved an application under section 142 in some very abject circumstances. If Your Lordship may kindly see.
What are you seeking? What?
I am seeking, because of their gross misconduct, Your Lordship had considered our case and previously and passed an order considering those reports. What had happened is that the child is now going to turn 16 and this litigation is pending since 2012.
Your daughter is with you now.
Yes, sir. And they are not letting the litigation to end at all. It will continue for the next 2 years. On every week, there is one application or the other which they file in Honorable High Court or the Family Court.
What do you want us to do?
That to dismiss their case, sir. Because it is no longer running on merits. It is running only on vindication. And
Case which is pending where?
in the guardianship petition in Saket Court. Your Lordship, let me just tell you one thing.
In exercise of our jurisdiction under 142?
Yes, sir.
Why should we do that?
Because I will tell you, sir. I will tell you, sir, that
the misconduct was that he had taken the child to a COVID containment zone. The child contracted COVID. I lost my father. I was on deathbed. And then later on,
Close it, everything closed. Come on, next match.
sir, please then at least let it be time bound. It is going to go endlessly.
He is before us. You are the respondent. Next match.
Sir, but I moved an application, please.
Make a request to that court concern. Next match.
Sir, I'm only requesting that the child. Sir, all his rights have been stopped by Honorable Supreme Court.
41. Take down. This petition arises from judgment and order passed by the High Court of Delhi dated 20th of November 2024 in CM bracket M 1523/2023, CM application 48279 of 2023 with CM bracket M 2100/2024 with CM application 18875 of 2024 and CM application number 26720 of 2024 respectively. It appears from the by which the applications filed by the petitioner herein came to be partly allowed. Good point. It appears from the materials on record that the petitioner herein it appears that the dispute, this litigation appears to be one of a matrimonial dispute between the parties. Is something. Good point. An application was filed by the petitioner under Order 18, Rule 17, read with Section 151 of the CPC for the purpose of leading fresh evidence and cross-examination of the respondent herein, who is none other but his own wife. This litigation is pending in the family court, New Delhi. The litigation relates, this is under the litigation between the parties in the family court is one under the Guardianship Act. Full point. The High Court disposed of the applications accordingly. Good point. Having heard the learned counsel appearing for the petitioner and the respondent appearing in person, we see no good reason to interfere with the impugned order. Keeping in mind the interest of the minor daughter and with a view to put an end to this legal battle between the parties, we direct the family court to see to it that, what is the case number?
GP 48/12.
See to it that
48.
48.
the guardianship petition capital G-48 of 2012 titled Neet versus Ritu Taneja is taken up for hearing and the same is disposed of in accordance with law without fail within 3 months from today. The disposal of guardianship petition G-48 2012 shall be reported to this court accordingly. Next matter.
Your Lord.
Thank you so much, sir. Thank
There's only one issue as well.
Yes.
The grandmother, the second petition, which was CM number 2100 of 24, related to not visitation rights for me because I volunteered abeyance until I am to prove what is actually happened. My mother, who has been in the ICU, currently is back in ICU 82. Some visitation just on VC, let the daughter meet her one and only grandmother.
Sir, my daughter has been interviewed by honorable judges, and she has expressed her views very clearly in front of them, in front of these counselors who were appointed.
We keep all contentions open for the parties to be canvassed before the family court.
Thank you very much.
My lord's permission if payment. That part both of us are here on the 16th. Your lordship's bench is also there next week. Can we be accommodated? It's a joint request. Next week, 16th. I just heard that my lord's bench is going to continue next week. That's
Beg your pardon?
That part had matter, my lord.
Yes, we are aware of it.
Yes, my lord. And we heard that the bench is there next.
Heard anything? Huh?
Oh, that was my impression.
Whispers in the corridor.
No. That's what I heard my lord say. My mistake, my lord. But 16th, if it be possible.
16.
We are both here. And Manoj, can I request if it can be kept on top of the board? It's a top of board. So,
Manoj, may I mention?
Much obliged.
Manoj, may I mention item number 50, wherein this honorable court has issued notice in the civil appeal today only, my lords. With that civil appeal, there is an IA for condoning the delay in refiling the civil appeal, my lords. It's 90 days only, my lords, which has not been mentioned during that time, my lords. If this honorable court may direct for condoning the delay.
That IBC matter.
Yes, my lord. Much, my lords.
Item 44, my lord. This is Neet PG matter, my lords. This was listed last week, my lord, regarding this publication of answer keys. If my lord, there's some urgency, could have it next week, my lords. The counseling.
Go to next.
My lords, on item 44, item 44.
Actually mentioning his matter.
Yes.
Allow him to complete now.
So, my lord, the counseling is starting on all the.
इसको 2 week के बाद top of the board पे लगा.
Very well, my lords.
My lords, in item.
Nobody will speak from this side. It will go like this. Yes, sir.
Sir, in 43, I just needed 2 weeks time to file a letter.
Granted.
Milord, in 43 only, Milord.
Unlisted matter. That is SLP number 16661.
What do you want?
This is a demolition matter, my lord. This will be taken on Monday, my lord. My lord has directed us to. My lord has directed.
This quorum.
Yes, only this quorum. This quorum has passed on 21st August 2025 to demolish the encroachment part voluntarily by the petitioner.
Have you done it or not?
My lord, then meanwhile, Panchayat has passed a detailed order and stated that we have not made any encroachment and we have also
You managed it. Let the panchayat people be here.
Yes, my lord, responding number 5 and 6.
No, we directed you now. Are you supposed to comply with our directions or go by the order passed by the panchayat?
This is the Calcutta matter.
Yes, ma'am.
Disposed SLP, no?
No, it's not.
You are in contempt. You are in contempt, including the panchayat people.
No, may I take a moment?
ये next week लगा दीजिए.
Lordship, what I am making.
Your Lordship.
Polished by the Panchayat authority.
Fine.
That's why I'm responding.
Have you complied with our order or not of demolition?
My lord, actually, it was.
You're not.
It was done by the demolition done by the Panchayat authority itself. My lord.
After our order?
Yes, my lord.
Then now what is the problem?
My lord, what happened, my lord? First, they have passed this order that Panchayat has been empowered to negotiate with us the encroachment.
Fine. You have demolished, correct? Make a statement on the next date.
Yes, ma'am.
Your Lordship, my humble apologies. I am mentioning, Your Lordship, item 44 again. Your Lordship, counselling for several states notifications have come. Your Lordship, 2 weeks time will be very late. Counselings will start and petitions will become futile, Your Lordship, because a lot of discrepancies have been raised in writ petition Meghraj Roy versus NB, Your Lordship. We have challenged the result also, Your Lordship. Your Lordship, humbly apologize.
What dusty?
That's why we can provide this order to Panchayat.
Again, you want to negotiate. You negotiate, get an order, then on the order you want to negotiate.
My lord, item 45, may I mention it's an arbitration appeal. The tribunal is in fact currently it's stayed. The arbitration proceedings are stayed. So, my lord, give any short name.
Your Lordship, I am appearing for the respondent. I seek time to file the reply to the item number.
क्या हुआ? Yours is 46, Ms. Narima. Not
Sorry?
40.
45, my lords.
45.
45.
Oh.
In fact, it's been 4 months since notice was issued. It's
Your
still at
Lordship,
5.
the client is from Agra, Your Lordship. The,
45 or 46?
Your Lordship, some time may be given to file reply, Your Lordship. Some
Are
time.
you all mentioning the correct matter, correct serial number?
Yes, item 45, Sunita Sachdeva.
Sunita Kashyap is
Yes.
Virola.
Notified after. Quick date.
My lord, we have a small request. Ours is item number 42. Jagtaji infrastructure.
Please,
so if
it turns out to be a big request, then you.
it's a very small request. If you can put the matter for an early hearing, because it is a very small matter and it has already been covered by this honorable court's judgment.
I don't have any objection.
Okay, इसको भी कोई date नहीं.
My lords, may I mention item 47? My lords, item 47 is regarding the tender matter. I'm requesting for next week, my lords.
You all can make a request. Arrest them also.